Hello, everyone. Thank you for joining us this evening. My name is Andrew Lavoie, and I'm the Design Challenge Coordinator for UB CoLab. And I'm also helping with TJ in terms of running the UB Masterclass series. We're excited to have you all join us tonight. We have a great panel tonight with some great experts in the field of intellectual property. We're going to share their knowledge and expertise with you. For those of you joining, the format for this evening is we're going to have a little bit of Q&A. I'm going to introduce our speakers, chat with them a little bit about some various topics around what the work that they do, intellectual property, and then we're going to leave the floor open for questions at the end. As we go through this, if you do have particular questions that you'd love to see answered, please make sure that you post them in the chat. We'll make sure that those questions get asked. Otherwise, once we get to the end, feel free to use the raise your hand function to indicate if you have a question, and we can make sure that the question's answered. So without further ado, I'd love to introduce our speakers for this evening. David Teskey is a partner at an Atlanta-based law firm of Alston & Bird, where he was a leader of the technology and privacy practice for over a decade. He concentrates his practice on the exploitation, leveraging, and transfer of technology intellectual property rights through complex transfer and licensing transactions and sourcing transactions, and managing intellectual and technology issues in merger and acquisition transactions. Highlights from his time as a lawyer include representing AT&T in securing the exclusive rights to launch the iPhone, and representing Virgin Galactic secure the technology and vehicle designs to build space delivery systems. David, thanks for coming out tonight.
Welcome.
John Leroy manages the IP litigation department at the law firm Brooks Cushman. He has been litigating complex IP cases for 25 years with several $100 million plus plaintiff and defense verdicts and jury trials for or against companies such as Apple, Microsoft, Sony, Ford, Verizon, and others. He represents individuals, startups, and large multinational corporations pursuing or defending against IP claims, including patent infringement, trade secret misappropriation, copyright and trademark infringement. He also manages the firm's open source software management practice. John, thank you for coming out this evening.
Thank you for having me.
Last and certainly not least, though, Adam Thompson is a partner in the intellectual property group at Morris, Mann & Martin LLP. He works primarily with early stage and mid-sized high growth companies to build a strategic business focused approach to protected IP rights. Adam's practice is focused on working with companies to build, manage, and deploy an IP protection strategy. He has also worked with enterprise companies to protect their patent portfolios, including Amazon, Nike, and Dell. Adam, thank you for coming out this evening.
Thank you for having me.
So, kind of get this ball rolling started. I'd like to start with you, Adam, and really get to the basics. So, what's the difference between patents, trademarks, and copyrights?
That's a great question, Andrew. So a patent is going to cover a novel invention, which is something that typically is based in technology of some sort, whether it's a machine process or transformation of some kind of commercial good. Usually, it is most often identified by solving some technical problem when building out a business. So early stage companies are usually solving a lot of complex issues for their customers, usually in a specific way. And the way in which they're solving challenges that are not already solved by the market are typically patentable things. In contrast, instead of protecting the underlying idea itself, a copyright is going to protect the expression. So, for example, you can write a book, you can do a performance, you can record an audio track, you can make a video, and the exact expression that you have is protected. So your book is protected, but somebody else can write a similar story or do a similar video as long as they're not copying the exact expression, or at least likely confusingly similar to the expression that you're doing. And then last is a trademark. A trademark is different because, first of all, it lasts into perpetuity if you keep using it, but it's a word, phrase, symbol, or combination, logo that is typically means nothing, and you select it and then build a brand based on it and build goodwill with your customers. And then they start to recognize you as the source of goods that are good. And in exchange for you filing your registration, they will allow you to have exclusive rights in your field of use for that mark. So if you think about Nike, for example, you wouldn't want to buy a shoe that doesn't have the swoosh on it or doesn't have the look or aesthetics of it. So they protect that with trademark protection.
Thank you. Kind of going off that a little bit, it sounded like you alluded to at the end, but I've heard about these concepts of provisional versus a non-provisional patent. So what's the real kind of concept behind that? And what's the difference?
Yeah, so first of all, not all patents are created equally. There's a variety of things that could be disclosed in a patent application. You can write a patent application that has dozens of inventions. You can write one that has one invention. They can be very long or they can be very short. The main difference between a provisional application and a utility application is that the provisional application doesn't technically have to follow any of the requirements that the utility application has, which typically makes it a little bit less expensive to prepare, or even significantly less expensive, because you don't have the formal requirements, right? We don't have to do black and white line art for drawings. We don't have to do claims at the end of it, although there are reasons to put at least one claim in the application. We don't have to have all the formal parts like the background and the abstract at the end of it. We can file with the main disclosure and then kind of buy you up to a year to convert it into the non-provisional application. And then a non-provisional utility application is going to be the full application, full patent that is looked at by the patent office. So they don't typically ever even look at the provisional application. It's just a 1-year placeholder.
Awesome. Great. Thank you for that. So it's really just there so that they can finish up the rest of the process until they can formalize it down the road.
Yeah, that, and it also gives them the ability to continue inventing. So oftentimes early stage companies, they have an idea and it evolves over time. So you can get the earliest filing date when you would have had the idea as you develop over the course of the year.
Awesome. Thank you. So continuing the kind of we're looking at this. So when should a startup begin looking into IP protection?
Yeah, this is a complicated question. As soon as you offer for sale, publicly disclose a concept, you lose rights in much of the world, and you start a 1-year timer within the United States. So typically, companies will file before they start selling a product, offering it for sale, and presenting on it, telling people about it. The problem with that on early stage companies, though, is that there's often a pivot that occurs later on to find and follow the customer, right? And oftentimes early stage companies may change direction a few times. And you want to make sure you have adequate patent protection in place by the time you start scaling revenue, for sure. But if you go too early, you get into a problem that you end up protecting things that aren't actually what you go to market with or aren't actually what you build revenue with. And so it's a little bit of a balancing act of being able to make sure that the thing that you're actually filing for patent protection is forward-looking and it covers what you're actually going to go to market with to scale revenue.
Great. Thank you, Adam. Final question for this particular section. One of the things that we hear often in CoLab from students are concerns about the cost when it comes to intellectual property. So could you talk a little bit about, are there any ways to either reduce or delay costs when it comes to protecting IP? And are those routes that startups should pursue or not, as the case may be?
Yeah, that's a good question. So when you're dealing with like an enterprise level customer, they typically want patents to be unitary inventions. They may have a family that builds on each patent, but they don't want to cover all over the map. So they want to try to have discrete separation between their inventions and file them in individual patent applications. When you're dealing with startup companies, it's more common because every patent application you file needs a separate filing fee, and it has prosecution efforts that happen, usually around 19 months from filing. You start getting more legal bills for responding to office actions. And if you file a patent application with one filing fee, you get up to 100 pages by default with your fee before you have to pay excess claim fees. So with an early stage company that doesn't have a very discrete separation in their invention, and they more have a novel business model that they're going to market with technology, it can often be helpful to create one complex, longer application that has multiple inventions in it, understanding that 3 years later, 2 years later, 4 years later, when the patent grants, and maybe there's a venture capital raise, or there's an angel round, or you did your Series A, you can branch that out and get more protection from it, as opposed to paying multiple filing fees and multiple prosecution efforts. Now, we always would prefer to do it the discrete way, but it's often cheaper in the midterm to file a larger application, or one or more larger applications that are covering multiple inventions. And then the other thing that you can do is file for a PCT application if you're interested in foreign protection. And that gives you the ability to preserve your place in line for 2.5 years, which lets you kind of build your revenue and grow the company to where you can afford if foreign filing is an interest of yours. And that protects up to 167 countries that you can enter 2.5 years from filing. So it's a great delay strategy to kind of hold off having to make elections as to what countries we want to go into. With a caveat that I've seen a lot of early stage companies invest heavily in foreign filings, and it's a really expensive path long term. And if you don't have a realistic 5-year window to get into the country that you're trying to file in with real economic prospects, it's something you should think hard and long about before investing a lot of resources when resources are tight.
Great. Adam, thank you so much for that. Appreciate that.
You're welcome.
Hey, Andrew.
Yes.
This is John. I just wanted to follow up on a couple of points Adam made. And just things I've learned over the years working with individual inventors and startups. Timing is so important, and Adam's right. It's it can be too early, it can be late. There's most companies have a sweet spot, but you don't know that you're in it until you've passed it. And so, sometimes I'll inherit an invention in the context of filing a patent application that came a little bit too late. And I say, why didn't you call sooner? And they would typically say, well, we've heard it's very expensive. Patents are very, very expensive. They can cost, $10,000, easy. And I said, yeah, but a phone call, first of all, a lot of the phone calls, they don't last long enough for me to even bill for them, frankly. Phone calls are effectively free. They're not really free if you do make a lot of them to the same lawyer. But my advice is, if you're a startup, if you're in a space where you're actually inventing, secure a relationship, just a friendly relationship with a competent patent lawyer early, just so you have someone to call and chat about ideas, 15 minutes here, 15 minutes there, maybe even a half hour, because the value of the advice you'll get will help with timing and strategy, and it's worth every penny. And that doesn't, just because you call them doesn't mean you have to, buy a $10,000 patent application. Also, the provisional filing, they are great for startups. And I still advocate for them because they have the lower cost of not having to meet a lot of the formalities that what we call a regular patent application requires. So there are cost savings there, but one of the pitfalls I've seen over the years, at least when it comes to enforcing your patents, is that provisional still has to have a very thorough description of your invention. And that, the good news is something that you, as the inventor, if you're the startup, you can really help with. You don't have to be a lawyer to describe how your invention works, and it's really a partnership with your lawyer. So while you would save cost in filing what's called a provisional, and it lasts a year, and I think it's a great opportunity, you just have to be very, very thorough in your description, because those legal standards are the same. Just one remark on that.
No, very much appreciate that, John. Thank you. And kind of going off that a little bit, if don't mind me jumping around a little bit. You talked a little bit about, there's benefits for, IP rates when, cost to obtain enforcement is so high, but who covers the cost of enforcing IP rights? And does the loser end up having to pay the other side's legal fees?
That's a question we often get in the very beginning. So in other countries in the world, in fact, most countries outside the United States, the loser has to pay. And that means if the plaintiff who holds patent rights sues a defendant for infringement, if that plaintiff wins the case, the defendant has to pay not only what I'll call damages or the royalty for infringing the patent, but also has to pay the plaintiff's legal fees. And legal fees, if you have to pay them by the hour, can easily easily be $1 million, 2 million, 5. It just depends how long the litigation lasts, and that's of course cost prohibitive for a lot of startups. And I should add, in other countries, if the plaintiff loses, the plaintiff has to pay the defendant's legal fees. But in the United States, for policy reasons that we're not going to get into today, we don't have that. Each side pays their own fees, absent some remarkable, some egregious malfeasance on the part of one party or the other. Whether you win or you lose, whether you're plaintiff or defendant, you generally pay your own legal fees, and that drives the price up, especially for a startup. But I can also tell you that over the years, I have both represented and defended against claims brought by individual inventors and startups. Anybody that does litigation will tell you they're not uncommon, and they can be very, very successful. And I have experienced that, representing individuals and corporations. Those are contingent cases. So sort of like the ones you hear about on TV, have you been hit by a car, hit by a train, call me, and no fee unless you win. That same paradigm in the United States does exist with respect to patent litigation. And so don't let the high cost of patent litigation cause you to not pick up the telephone and call a patent lawyer, make the investment in a provisional or a utility patent application. You absolutely should do that, because, as I'm sure will be talked about today, when you go to sell or compete, you're going to be very, very thankful that you made that early investment, to protect your intellectual property rights.
Yeah, and as was said by my first mentor, a patent is a expensive ticket to a more expensive dance of litigation. It's the way he always used to frame it.
Yeah, that's right. But while there is no contingent opportunity for getting the patents, and I've been part of a startup myself, and I know that in some startups, the cost of a patent application actually can be a huge part of a budget that could be used for building prototypes, hiring employees. It's a very, very difficult investment to make. But I think all the people, at least on this class, can tell you it's a worthwhile investment, at least done, with the right supervision.
Yeah, and that's where your point, John, about timing comes in. Is really when as you're moving on your path and you're evolving as an enterprise, when it makes sense to start making those larger investments and costs in registering your intellectual property. And that's very just conditional on the situation that you're in, the technology that you're in, what other people are doing in the field. And that's why, as John says, picking up the phone and calling an expert to help you walk through that and consider what all the variables are that you should be thinking about is very important.
Thank you. That's phenomenal. I think, actually kind of going off that a little bit, can we chat a little bit about kind of like, we've talked about the costs and the rest of it. What are some of those like general realistic, like, that startup cost or I should say, what is a cost for the IP for startups, in general, is like they should be thinking about? And actually going off of that, what are some of the things that you find startups have skipped in this process, or in their kind of like startup funding process, that impacts the work that you do?
Yeah, for me, and where I see a lot of this is I end up, because of our practice here, I end up representing companies that are buying startups, or representing companies that are buying later stage companies. And there's a lot of work that goes into what's known as the diligence of the target, and frankly, just shining the flashlight on anything and everything that's been done in the history of the company. And if it's a technology-based company, understanding the technology and, importantly, where it came from. And so sometimes you hear the phrase, it's not too late to win. However, in the field that we're talking about here, it's actually not too early to lose. And one of the biggest problems I see when you're looking at a target is in those early days when it's a limited number of people and you have friends who are coming in to help and assist, and friends of friends, tying down and making sure that you have the right assignment documents from everybody who has been working on the technology to make sure that the company is becoming the owner of that technology. Sometimes, a lot of times, particularly in the early stage, there are no formal employees. It's just a group of people who are, they don't know it, a de facto partnership. And you need to make sure that all the people who are interacting with the business are entering into agreements where they are signing the results of their work and their innovation to the company. So that later on, when the company gets to someone like me to take a look at, I'm going through and I'm asking, tell me all the people who participated in the development of the intellectual property. When were they there? What did they do? Show me the agreements that you have where you made sure that you got an assignment of the intellectual property that they were creating. You will also deal with contractors. Same thing with contractors. When you are small, you will likely not be able to do everything yourself, or you will have certain expertise that you will not have, that you will have to go outside and hire a contractor. You need to make sure that all of those agreements have the assignment of anything that's been developed, and then also the confidentiality obligations around what is being developed for that contractor. That's probably the thing that I see that creates the most problem is where was the intellectual property created? How does the target have rights in that intellectual property? Another very difficult area is many times you have early stage companies who end up working with another company because they feel that there's some synergies, and they also may not paper things very well about who's doing what and who's going to own what comes out of that. And I'm sure that John, probably John and Adam would agree, there's a tendency for people to say joint ownership is great, then we don't have to worry about it. Joint ownership just creates the biggest headaches in intellectual property that you can think of down the road. When I think of other issues, particularly in the technology area, and I know John specializes in this as well, the introduction of open source software into code bases. Everybody uses it. It's almost impossible not to use it. But someone like me is going to come in and say, tell me about the open source that you've used. Tell me about the open source that you've used to create your product. Tell me about the open source that's embedded, that's linked inside your ultimate product that you're using. Show me the versions, show me the licenses. Have you done a scan? Have you hired an outside third party like a Synopsys, which is a consulting company, to come in and do a code scan and to be certain of what source code is sitting inside your base? Have you done, maybe there's a lot of it's kind of hilarious. There are a number of open source scanning products that will scan for open source. Have you done anything internally? Do you have policies about the introduction of open source into your code base so that you know what's going in and you are making sure that it meets your requirements and it's not exposing you in particular ways? And then particularly for ventures that are going to be in the consumer space, data has become a very important aspect, intellectual property adjacent, but I think it's worth mentioning. If you have a business that is going to be collecting a lot of information, especially personal information, you are going to get questions, and you want to, when you are early on, making sure that you are doing the diligence in that area to make sure that you are collecting the data appropriately, you are getting the consents that you need to, you are siloing that information for the different ways that it can be used and it can't be used. That is extremely critical and will continue to grow in importance as legislation is not done on how to handle data. And then the last thing I'd say on this topic is, at some point, and this is all the timing question, you will want to do what's known as a freedom to operate analysis. And that's to take a look around and see what have others done in this space with intellectual property, what rights have others obtained, say, in patents. Do we have to avoid those patents when we are starting to build our product? Are there ways that we can design around those patents? You don't want John sending you a complaint to once you surface your business and potentially stop the entire venture in its track. And so that's another key thing that you can do early on. But as with everything else that we've talked about, it's a question of timing. It's a question of cost. You don't want to do a freedom to operate, as Adam was saying. Many times you pivot. Okay, so you don't really want to do that freedom to operate early on before you pivot and you know exactly where you're going.
Thank you, David. One of the things you touched upon, and I think this goes to what everyone has kind of discussed so far this evening, is a lot of the internal stuff that IP and companies need to consider about it. But one of the questions that we do get a little bit frequently from students at the later stages is, what are the sort of disclosures that companies should be making regarding IP as part of a funding round or a sale to those external partners who may not be directly involved but might be interested in the company?
Yeah. If you are going to have a company that becomes involved in a funding round or an acquisition, or some type of equity stake, some of the early levels, you may not have a significant amount of questions on the diligence side. The dollar amounts are pretty small. But when you start getting up into more serious money, and you have attorneys who are brought in on the diligence side, you are going to see a standard set of diligence requests that you will need to respond to the best that you can. And this is going to be a bookend to what I was just saying about you really need to take care of some of these things early on, because when you get to the stage when questions are asked of you, if you've not captured that information, it's going to be very difficult to recreate it or find it in the future. So we talked about the employment agreements, the contractor agreements, making sure you have all of that buttoned up for the assignment of the intellectual property. They're going to ask for a detailed listing of the intellectual property that you own that you think is important to your venture. And that can be the formal intellectual property that Adam was talking about, the patents, the trademarks, copyright registrations, domain name registrations. But it's also going to be things like know-how and trade secrets, because today, there are a number of companies, and it is a reasonable decision to make, that their secret sauce will remain secret and protected by trade secret and not be disclosed by patent. Because what the trade-off on a patent is, you will receive a monopoly on the claimed invention, but in exchange, you have to disclose what you are doing with sufficient detail for someone else to practice that invention. So there are plenty of companies who today make the decision that when I take a look at the length of time that it takes to obtain a patent, and how fast this technology is changing in my area, that the technology is going to run past that patent. That is, by the time it issues, there's a possible chance that it really is not going to benefit me that much. And I would rather go with trade secrets. Plus, also, a lot of technology today is underneath the covers, and the people who use it don't really have an opportunity to look at it and dig into it to be able to reverse engineer to then potentially create a competitive product, because you just can't get to it. If you think about all of the services that are on hosted software, we don't get to touch that software. We don't get to see that software in operation. It never comes to us. It sits up on the cloud somewhere in a server in the United States or somewhere else where it's being hosted, and you just get the results of the service. So you're going to need to outline what the intellectual property is that you have. Many times listing out the software can be the most difficult. We've talked about the open source questions that you're going to see about it. You're going to see questions about viruses, and you're going to need to verify that it has no viruses. They're going to want to know whether or not you've had to release your source code to an escrow because you have a first client who says this is great technology, but you're a risk, you're small. I want you to give your source code to an independent third party. And if your company goes bust, I get to pull a copy of that code and keep running it myself. They're going to ask for all of your inbound and outbound intellectual property agreements. Your outbounds are mostly going to be customer agreements to the extent that you have them. The inbound could be you needed to bring in some intellectual property from a third party. You're going to have vendor agreements. You're going to have supplier agreements where you receive intellectual property rights, mostly software and the ability to use certain software in the operation of your business. As it is 2024, we are obligated to bring up AI in any conversation that we have as lawyers. You will start seeing questions now about, did you use AI in the creation of your product? Is your product AI enabled? Let's talk about if you were creating AI or you used AI, what kind of data sources did you use for training? Have you had any ethics and bias reviews of the AI that you've used? What are your AI policies? What models have you used? Third-party models or created your own models? We talked about the data collection. If you're a business that has a lot of data, all of those questions around how did you collect your data? What policies do you have? How do you use it? Who do you share it with? Do you monetize it? Those will all come up. They're going to ask, has anyone ever sent you a letter that has asserted that you potentially, the operation of your business infringes someone else's intellectual property? Have you ever sent out a notice to someone saying you think they've infringed your intellectual property? They'll ask about, have you received government funding? Have you received university funding? Are you a member of an organization that sets standards? Because many times membership in those organizations comes with some strings attached about patents that you may obtain and putting those into the standard setting organization for general use. And they're ultimately going to ask you to say and stand behind your product and say that what your business is doing does not infringe someone else's intellectual property. That's a hard statement to make. Nobody knows that for certain. You can't do all the research, but that will be something that they ask you to do.
Thank you, David. I'd like to open it up for this as well for all three of you. I know with legal rights, sometimes you can't talk about names specifically, but are there any examples that you can talk about startups that confronted or successfully litigated for its patents that you've worked with or you know about that you felt like drew a really powerful lesson from?
Oh, sure. I could jump in on this one. So I've represented a couple of inventors and startups, in both cases. I mean, bright people, well educated, but didn't have a lot of resources and really started with nothing. One was a gentleman, a PhD physicist, and his partner, an electrical engineer. They both had children. Their children grew up playing Super Mario Brothers on the original Nintendo Entertainment System, which you today would only see in a museum. And the parents became so sick and tired of driving their children to other people's house that they decided to build a telecommunications module that would allow them to sit at their own house and plug their Nintendo into this magic box that would talk over the phone lines and allow them to play each other over the telephone lines and, be able to use a headset like I'm using now. So they could, trash talk, because if you can't talk, it's not nearly as much fun. They hired a local patent lawyer. They received a patent. they built it. It worked. It was great, but they didn't really have the money or the resources to start a large company. So they tried to license their patent, which is basically they tried to find somebody that would be willing to use it, and pay them, royalty for it. And so they reached out to a lot of companies, including Microsoft and Sony. But Microsoft and Sony both said they were not interested. They had no current plans for connecting, video games over any kind of a network to be able to play remotely. And of course, we all know today that that's ubiquitous. Nobody would even buy one of those devices if you if you couldn't play over a network. And so they took Microsoft and Sony on and fought for 4.5 years. And ultimately settled. That case didn't go to trial, but it was definitely life-changing for them. They were paid very, very well. And then just one other instance was an individual, very small software developer that many, many years ago thought that the access key that would be associated with a computer program when you license it, like the product key. We've probably today we don't use it, but back in the day you'd get a piece of software and the only way you could use it is by typing this long alphanumeric string. But the community would just share them, right? They would just share. If you had the string or you could find a string that was valid, you could just basically use the software for free. And the software developer wrote an application that would basically take the fingerprint of your hardware and associate the software not just with this key, but with the computer it was installed upon. And he was a hardworking person. He was in computer science, but I don't even think he had a computer science degree, but he had a great idea. And he actually started a company, which still exists today. And he made that and he offered it to in this case, Microsoft, who also said they had no interest in such a technology. Then, about 6 years later, they came out with it, and he took them to trial, jury trial. We tried that case, and he was awarded like, I don't know, $150 million or something. And then that was appealed because an appeal is a big part of this process. But that obviously was very life-changing for him. And he gave most of that money away to charity, believe it or not. But he still runs a software company. He's still a pretty humble guy. So the American dream, I guess it's international, is very real. And all the scary lawyer talk and expenses, they are real. But I think everyone on this call can agree that it's a wise investment to make under the right circumstances at the right time. Subject, of course, to David's very accurate remark about trade secrets, which is kind of in some ways the opposite of a patent. That's a decision you and competent counsel should make, but it's a decision you should at least all think about in the context of a startup.
Yeah, I have a similar one where a client made a popular beverage dispensing solution and didn't file any patent protection, got years down the road, got big enough that they became a target, and another company came and filed a patent lawsuit against them for a patent that we believe was clearly invalid and clearly a problem, and it still cost them hundreds of thousands of dollars to get to the point where they were able to dismiss it, even though they wanted nothing to do with it. And if they had probably filed earlier on what they were doing, they would have avoided a lot of this because their patent probably would have been prior art to them, which is interesting. Another point that you had made, John, that I think is interesting, that the serial tracking number, I have unfortunately been exposed to some interesting problems on copyright that's going on, where when I was a kid, people, not myself, would BitTorrent or download or do whatever to install software. But now the key tracking software fingerprints your hard drive and fingerprints your computer and the network that you're on and tracks all your usage. And what some of these companies are doing with their software is they're literally exposing it on purpose and then coming after you for infringement of their registered copyright because they know everything that you've done with their software. They have all the data, and the statutory damages for registered copyright infringement is pretty steep. And I had one company get basically told that they got to pay a 6-figure settlement acquire a license to the software that they didn't even know their engineer on the team was using. So having, like David had mentioned, having really good policies in place to manage what makes it onto your corporate devices, what open source software that you have, very important. On the open source side, when I was an engineer, I used a lot of open source software, and my company had been acquired. And I got a question from the lawyers, and they said, are you guys using, what open source licenses are you using? And I said, no, we verified all this stuff. There's no issues. And the director of our organization said to me, Adam, you're not a lawyer. You can't make that decision. And it infuriated me. Shortly after I went to law school, while working there still, and I transferred to the legal department, and the first project I got was involved in auditing all our open source licenses. And sure enough, I had no idea what I was talking about before, because we were definitely doing a lot of things that violated open source rules. So yeah, it's a complex thing.
So, well, I think now would be a great time for us to open the floor to questions. If there's any students who have questions about any of the topics or for any of our guest speakers, feel free to either raise the hand via Zoom or put it in the chat, and happy to kind of address those.
One thing I want to mention is, as you're thinking about building the companies, many times as you're building your solution, you will have someone who comes in as like a first funding partner or a first partner. And one thing to be cognizant of, and I'm going to use the word worried about, is that big whale that comes in at the beginning. They can start to get you to move the direction of where you were going, because they have needs, and they start getting you to go their direction, and all of a sudden you realize you're not doing what you plan to do, but you're actually working for them, because they're the ones with the money, and they're going to give you the money to do something that helps them more than it helps you build the company. And it's hard to say no to that, but you need to recognize when it's going on. Right now, there's one company that I'm working with that had a in the healthcare space, AI healthcare space, and they had a billionaire very interested in them, and he set up a meeting after they had talked a couple of times. They went to talk to him, and it turns out he had set up a meeting with a client of one of his businesses, where it wasn't a meeting where the people I'm working with were going to talk to the billionaire about this product. The billionaire was bringing them in to talk to the customer of his business, as if he already had the technology in hand and wanted them to demo it for the customer. And so that type of thing can happen, and you just need to be aware that there are warning signs. You'll see them when you start realizing you're spending more time thinking about your funding sources priorities than your priorities.
So yeah, one other pitfall that I've seen more than once that's very easily avoidable, again, just with a little bit of knowledge and early advice, and David touched on it, and I think Adam did too, is having those, we say, have your early agreements, in place and buttoned up, the I's dotted and T's crossed. Well, one of the, in my view, most important agreements that every startup should create at the earliest possible date, even if you have to steal one off of Google because you can't even find the time or the money to call a lawyer, is an operating agreement among yourself and your partners, which, if nothing else, of course, we're the IP lawyers, so we care about the IP, assigns all of their rights to whatever your startup entity is. Because one of the things that you can learn the hard way, either at the time you're about to sell your company or enforce your IP rights or something, is in the United States, individual co-inventors, whether it's a patent, a copyright, a trade, it almost doesn't matter what form of IP it is. If there's three of you that come up with it together, which it's almost always more than one, you each have independent rights to it. And that sounds great when you're best friends, right? You don't have to worry about it. But what universally happens is something. Either, the this idea becomes extremely valuable, and everybody starts, even though you're best friends about a week ago, now people start thinking about dollar signs and how they can individually profit, or there's a falling out. There's all sorts of things that can go wrong, and if they go wrong, they can really interfere with your ability to sell, monetize, enforce. When the big buyer comes a buying, one of the things they want to make sure is that you sort of have the rights. And if you don't have some agreement that says, as an employee, upon the moment that they conceive or reduce to practice an invention, it's automatically owned by the company. It's not. They own it. And if you didn't get that, it's just a hole you want to stay as far away from as possible.
Yeah, and not to get into real minutia, those agreements, the number of times that we see agreements that say X shall assign everything that they create to the company instead of X hereby does assign, which this is just language. That first one is sometime in the future, I will sign a document that assigns the intellectual property to you versus I am right now today assigning to you the intellectual property. So that's what we're talking about with getting it buttoned up and having the right language. It matters. It matters.
David, almost every IP attorney in the US knows that's the rule. How can every agreement I see in a deal have the wrong language? I mean, it's just mind-boggling. Where is it coming from?
Google, that's the problem. That's where they're all pulled from. Maybe Copilot will be better and draft better agreements for the internet.
Are there any other questions from the audience? Oh, Jason, I see your hand raised.
How would you best make a lawyer friend to ask questions to about all of the different inventions you make? What are some things that they would be interested in?
So, I mean, one way I'll right off the bat, Jason, is you can reach out through the UB program like you did, and you and I have had a meeting, I think, right? I believe we met before and talked about your business. So, your university system is certainly one way to do it. I would also say to look for companies, if you are a startup, that specifically focuses on startups because they have unique issues that arise. And I think we've all represented companies in that space, but a lot of the companies that are dealing more with enterprise level IP protection don't have a system in place to act as your in-house counsel. And the difference is, if I'm going to call Amazon, they're going to have 12 in-house patent counsel, 20 in-house patent counsel. They don't need me to think about their patent strategy. They need me to protect their patent or their IP. Whereas a startup company doesn't want to pay a huge salary to an in-house attorney, let alone an in-house IP attorney. So they need somebody who's on your wavelength to deal with some of those issues that in-house counsel would deal with and knows to look for them and be on top of them. And I've seen that get kind of fumbled with firms that don't deal with a lot of startups.
So you're probably also looking to find, look, cold calling a lawyer is a great idea. And I think John was absolutely saying the same thing. But I think that your hit rate and your success rate goes up if you try to identify some people who have a decent amount of experience, but aren't too long in the tooth.
One last piece of advice you'd want to share with our attendees this evening regarding intellectual property or anything related to maybe legal matters as they start thinking maybe about startups and their own businesses.
I'll start, which is a little twist, which is don't discount intellectual property as a career. I think that all three of us here have the engineering degrees, and we ended up as lawyers working in intellectual property. For me, it was a way to keep close to technology, but frankly, I was never going to be good at the technology to be an actual engineer, and I luckily found that out early enough. But to stay in touch with technology, and the great thing about doing what we do is you get to see a tremendous variety of intellectual property and things that people are working on and coming up with, and can really make a difference and impact people's experience and life.
So yeah, just one more thing to touch on with what David mentioned earlier. We have a joke that it's easier to divorce your venture partner than your spouse than your venture partner, and you know it seems counterintuitive, but venture funds and private equity funds, they have money coming in from partners, limited partners, general partners, and they, think about if I put $30 million in your business account and then you had to go make loans to people, or you had to go give that money out, because when it's sitting in the bank, it's not making any money. It's just sitting there. So the limited partners and the partners of the funds, they don't want the money to sit there. They need deal flow. They need to give out the money because they need to start that 5 to 7 year clock as to when the business is going to sell. And so when you get revenue and you get to the point where you're growing and you really need the money to come in, be very careful to select the right person who has some kind of ability to help grow your business, and look really closely at who's available and what options are out there, because there's definitely some startups that we've seen over and over again that get involved with fundraisers or venture funds or any kind of investment where they don't get along with the fund and they want to guide in a different direction or just steer them in a weird way. And when you're really money hungry, it's hard to turn away money or to avoid something. But if you're really building a valuable company, there's a ton of people looking to give money.
That's a good point. I agree with that. And to follow on something David said earlier in his closing remark, I was a student at the University of Buffalo, just like you are. And it was a session very much like this about, it was back in 1999, I guess 25 years ago, that I met my first, intellectual property lawyer in some, I think it was a Tau Beta Pi session. We didn't have Zoom, hadn't been invented yet, but it was in person. And it immediately inspired me to pursue a career I guess I knew existed, but had no sense of it. So I encourage all good engineering students, of course, to become patent lawyers as quickly as they can. It's a great career, whether you're an introvert or an extrovert, anywhere in the middle. It's a broadband career. There's something in it for everyone. So I have to pass that on. But legally speaking, there's a phrase I use. I didn't invent it, but it's a plan for the divorce. And it doesn't sound that entrepreneurial or that inspiring. But I can guarantee you, whether it's securing your intellectual property, securing the operating agreement we talked about, which does have to be worded correctly, and you'd only have to be a lawyer to even understand these issues. Whether it's the non-disclosure agreements and the terms you put in the non-disclosure agreement. So when your information is going out or somebody else's information is coming in, and your employee termination agreements, throughout the continuum, which of course just starts in a garage somewhere or a laboratory, when you're drafting a legal instrument, you got to think to yourself, what happens when it terminates? What happens when the other side terminates? What happens when somebody breaches? Just ask yourself that question, no matter what sort of legal document you're talking about. And it help guide you to ask good questions. You should have a lawyer where you can ask those questions. Because when everybody's in love and we're all rowing in the same direction, you don't need the lawyers, right? You don't need the law. But as soon as there's a change of circumstance, which is inevitable, then you do. So as you go through your entrepreneurial life, plan for the exit. I guess that's my inspirational closure. So,
well, I just want to say, John, Adam, David, thank you so much for your time this evening and your expertise. I think we all learned a lot from tonight's session. Students, if anyone has questions you want to follow up on, feel free to email myself or the UB CoLab communication, and we can reach out and pass those questions along. Otherwise, thank you for joining us this evening.